Hello, everybody. Victor Huynh here from Ready Artwork. Welcome back to B2B Marketing in Plain English. I wanted to record this video because we've had some clients going through some legal issues recently, and I thought it'd be good information to share for everybody. So let's jump right into it. So if your website runs Google Analytics, Metapixel, or Google Tag Manager, and you have visitors from California, you could be getting into some legal issues right now and not even know it. And this is something that costs $5,000 per violation per visitor. There's this law called CIPA, California Invasion of Privacy Act. It was written to prevent wiretapping, but the courts are now applying it to website tracking, cookies, pixels, analytic scripts. And unlike GDPR or CCPA, I think those are things that you might have heard of. Those are GDPR is the EU version, CCPA is the California version of protecting consumer data. And those are typically set up for third parties not to be able to sell user data. So CIPA is completely different. It lets an individual sue your business directly. So the government doesn't issue a citation or a ticket. With CIPA, they can literally sue you individually. So plaintiff attorneys are scanning websites right now with automated tools, finding tracking violations and filing class actions. Here's the thing most people miss. You can be fully CCPA compliant and still get sued under CIPA. So CCPA is about sale of data, kind of what I mentioned earlier. CIPA is about whether you intercepted the communication in the first place. So two completely different laws. The lawsuits aren't about whether you track visitors. They're about when you track. When the tracking starts, whether it starts before the visitor had a chance to consent. So some of you guys might have seen like pop-ups on window for, do you consent? Are you okay with us tracking your information? You say yes or no, right? So that's the consent button we're talking about. On most websites I audit, Google Analytics fires the second the page loads. Metapixel starts collecting data immediately. Cookie consent banner, it shows up a couple seconds later. By then, the tracking has already been running. And this is actually a pretty common issue. That sequence is the whole problem. And the two recent court cases show exactly why it matters. So Bosley, the hair restoration company, just got hit with a CIPA lawsuit. If you want to nerd out on legal jargon, you can look up Sisti versus Bosley. This is a case where Bosley won. The federal courts threw it out on April of 2026. So these are fairly fresh cases. And why was it dismissed? In prejudice. So that means there's no appeal to that. Bosley requires users to accept terms of service before using a site. Those terms included consent of tracking, no tracking fired until the users agreed. So it was very clean. Go in, yes or no, before anything happens. The other case, AEG, the entertainment company, they lost. So if you want to look it up, Garcia versus AEG, and this was in May of 2026, so even more recent. They had a cookie consent banner, and that was the issue. Their tracking pixels fired the moment the page is loaded, before the banner even appeared. The court let the CIPA claim survive. The banner was there, but it came after the data was flowing, and this is a very typical setup. The same type of lawsuit, opposite outcomes. The difference was whether the tracking started before or after consent. Now, I want to be upfront. Courts are still split on some of this. Some say tracking pixel counts under CIPA. Others say CIPA only applies to phone lines. There's no final answer yet. But plaintiff attorneys are filing hundreds of these cases right now, and they don't need to win every single one. You need to be in a defensible position either way. Here's what to do. 1, check what fires on your website. If Google Analytics or Metapixels loads before your consent banner appears, that's the gap. Ask your developer to show you the load sequence. 2, block tracking until consent. We use Cookie Yes on WordPress sites we build here at Ready Artwork. It blocks Google Analytics, Metapixel, and anything in Tag Manager from firing until visitors make a choice. That's the Bosley approach. No tracking before consent. 3, don't assume CCPA covers you. Different laws, different standards. You need both. If you've already been served, talk to a lawyer first. After you speak to your lawyer, get your web team to document exactly what's on your site and when it fires. If they can't answer those questions, or you don't have a web team, reach out to us. This is what we do. The fix isn't complicated. Block tracking before consent. The companies winning these cases already had it in place. The companies losing didn't. If you're not sure where your site stands, there's a link in the description to book a discovery call. We'll look at your setup together. And again, subscribe if this was useful. I'll try to put out as many videos as I can, especially under my B2B Marketing in Plain English series. Drop a comment if you have any questions. I read every single one of these.